today we're going to talk about our initial consultation process here at Ferraris Law. To
Yeah.
help us understand a little bit more regarding what goes into our consultation, and especially why we ask so much and how the general consultation process works, we have
Mhm.
Christine with.
Yeah.
She handles our consultations at this point. Um, so I'm going to give it over to her. Christine,
Yeah.
welcome, and please tell us what you can regarding our initial intake,
Yeah.
consultation process.
Yeah. I wanted to address something that you said because I think you said cost so much or something so much. What was it that you said? And I just wanted to try to understand where that is coming from a little bit. What is
So
it? I'm sorry.
no, it's fine. So usually I handle our calls, I
Mm-hmm.
myself and a team member. So
Mm-hmm.
when a client sometimes call and we send them our initial intake form, that's when they usually ask, after we have done a conflict check, they ask us usually, listen, we got this email, so we add the consultation cost for our initial consults in that initial email.
Yeah.
So some of them always ask, why is it this amount of money? And then usually I tell them, because it goes hand in hand with an hour's worth of document review as well, and obviously our attorney's experience in years, you know.
Yeah.
So there's a lot of things that goes into that specific, consultation fee, basically, if I can say it
Mm-hmm.
like.
Yeah.
Uh,
Uh,
so yeah.
okay. So we have hourly rates based on our the experience that we have. For me, for other attorneys that might be working on the case, for paralegals and legal assistants, we have various hourly rates, and that's how we bill. And that's how we get our fees paid for when we seek them to be paid for by the court or by an opposing party. And these are based on market rates. These are based on the experience, as you said, and I just mentioned, it's based on my education. It's based on, because I focus on this particular area, and it's an area that a lot of, I would say 85% attorneys don't focus on, where you'll have a lot of attorneys that do personal injury, car accidents. You'll have a lot of attorneys that do medical malpractice, but you'll have very, very few attorneys that focus on auto fraud and auto warranties, service contracts, and so forth. So because of my experience and because it's a special type of area that requires the knowledge of the federal laws and state laws, and because I have focused on it for a considerable period of time, that's what goes into my hourly rate. And for the folks that work on our team, based on their experience and their knowledge and work that they've done in this area, their hourly rates are rated accordingly. I will say, and I'm kind of going into a little bit beyond the initial consult process, but our hourly rates, we try to use efficiently paralegals, legal assistants, and administrators. So I'm not doing that work. I'm focused on the legal work, and that makes for more efficient billing for clients. The hourly rate is actually a discounted hourly rate in some ways for the initial consult. And the initial consult is based on my hourly rate that I am able to collect if I go to court, based on the market rate for me. And right now, our hourly rates for the initial consult are $415, and that includes my time, which is the hour spent. It also includes the half hour of arranging the initial consultation. It also includes the 25 minutes. So it's really, it doesn't just include the 1 hour of attorney time. It's a lot of administrative work that goes behind the scenes to schedule the appointment. And then afterwards, potentially there's a time expended to bring that person on board that isn't charged, and it isn't part of the initial consult process, but is a gap of that process that does require time from our team members and me to look at the initial consult to evaluate whether or not we can assist that person going forward. The initial consult is not to solve problems. It is to provide clarity, so that the potential client, the consumer that comes to us, understands exactly what their potential claims are based on my knowledge. Now, we try our best, and this is part of your job, Lizette, to make sure that we aren't speaking with people in the initial consult that we don't think we can help. Now, if we're unsure, we try to help the consumer know that, like, hey, we think we this is something that we could help you with, but we don't know until we look at things. And so when folks call us and say, well, I need to know whether or not the attorney, this is a case for the attorney to take, we don't know. We can tell you, like, based on some of the circumstances that you put in your intake sheet, which is part of the conflict check to make sure we don't have a conflict with you or the other party that is involved or other parties. But at the same time, it's to provide clarity about what potential claims you have and what potential remedies you have, which means, you know, what kind of compensation can you get? Is this a case where you can seek attorney's fees and costs from the other side because of the type of claim? Are you within your statutes of limitations, which is your deadlines for filing claims? Do you have an arbitration agreement versus can you file a lawsuit? So we're providing clarity about the claims, and we want to learn more about the kind of harm that person has, so we can talk a little bit about that and what's recoverable. One of the things that I hear now and again is pain and suffering. Now, that's when you have physical injury, you get that type of damage to recover, but you still get emotional distress and type of damage. Certain types of claims, when they're what we call tort claims, like fraud and deception, and those are the kinds of claims where you potentially can get emotional distress, loss of time, types of damages. And so those are the things we talk about, and who the potential parties are. It's a lot of times the consumer comes to us and they don't understand that somebody else is also responsible for this claim. Maybe it's a financial institution that was part of the transaction. So it's to provide clarity. That's the purpose of the initial consult. And I hope I answered a little bit about how the fee is calculated as well.
Definitely shed some clarity on that. I will be adding our YouTube video, the one that we are making, to our emails as well, if I send it out to it.
So, yeah, that's great.
And then there was another question that we had potentially. When you are busy with an initial consultation, what can you tell us a little bit about damages or collecting legal fees and costs? You know, and what we do before filing a lawsuit, you know, other remedies that we try to take.
Yeah, so part of the initial consult process is to assess, as I said, what the potential damages are. But we don't know that during the initial consult. We have an idea and we can tell you what the law is, whether or not we can tell you, well, it appears from some of these documents, but we need more information. And that's part of our investigation process, which is what we do before we file a lawsuit. We have to investigate the claims. And so the next step after initial consult is investigation. And that's when we're retained by that potential client. And both sides agree, the potential client and the firm agrees that this is what we're going to do. And so we have an investigation process where we're reviewing the documents, we're getting more facts, we're finding out about the witnesses, we're learning about the chronology, we're learning about dates that trigger deadlines under the law. We're analyzing the law relative to those facts. And so what the damages are, we don't know. We have an idea, and that's something that's discussed, but that's part of the investigation process after the initial consult. That's our next step when we're hired. And that's whether we file a lawsuit or whether we just send a demand letter, which is for most cases is what we do. We don't generally file a lawsuit unless there's a deadline that has to be met. We make a demand after investigating the claim and analyzing it. We make a demand on the other side that includes legal fees and costs generally. I would say probably 95% of the work we do involves what we call fee shifting statutes, where the claim itself allows for the prevailing party, the prevailing consumer, to seek the recovery of legal fees and costs. Now, that's not always guaranteed, but the court must consider it if you're taking it to trial. And we always ask for it when we are trying to settle a case, because in the context of trying to find a resolution, it's understood generally that the legal fees and costs will go up. Sometimes the damages may stay the same, and sometimes they will go up as well, but the legal fees will increase. So there is an incentive to try to resolve it without filing a lawsuit. And that's one of the advantages of working with fee shifting statutes.
That makes a lot of sense. Thank you for clarifying. I think these questions that we asked is really going to be helpful for even our viewers right now. So, Christine, we want to thank you for your time and thank you for shedding some light on some of our questions we have for new potential clients and how our consultations work.
Thank you, Lizette, and I appreciate that, you helping me and the rest of the team to share this information with consumers and even clients that sometimes forget about how we're doing things.
Yeah, that happens.
Yeah.
But that's